Age discrimination versus other forms of discrimination. Welcome to our YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we will be looking at the legal concept of age discrimination in the workplace and how it differs from other forms of discrimination that might arise in the workplace and are also subject to statutory and other legal protections. The distinction as between age discrimination and other forms of discrimination, such as discrimination based on race, religion, ethnicity, gender, and sexual preference, is an important consideration, and something that came to the fore when I was reading a Supreme Court of Canada decision written by Justice LaForest in McKinney versus University of Guelph, where Justice LaForest stated the following. Section 15.1 of this charter specifically mentions age as one of the grounds of discrimination sought to be protected by that provision. And there is no doubt, as I've already indicated, that such discrimination, like the other categories mentioned, can constitute a significant abridgment to the dignity and self-worth of the human person. It must not be overlooked, however, that there are important differences between age discrimination and some of the other grounds mentioned in Section 15, Sub 1. To begin with, there is nothing inherent in most of the specific grounds of discrimination. Example, race, color, religion, national or ethnic origin, or sex that supports any general correlation between those characteristics and ability. But that is not the case with age. There is a general relationship between advancing age and declining ability. This hardly means that general impediments based on age should not be approached with suspicion, for we age at different rates, and what may be old for one person is not necessarily so for another. In assessing the weight to be given to that consideration, however, we should bear in mind that other grounds mentioned are generally motivated by different factors. Racial and religious discrimination and the like are generally based on feelings of hostility or intolerance. On the other hand, as Professor Ellie has observed, the facts that all of us once were young, and most expect one day to be fairly old, should neutralize whatever suspicion we might otherwise entertain respecting the multitude of laws that comparatively advantage those between, say, 21 and 65, vis-a-vis those who are younger or older. The truth is that, while we must guard against laws having an unnecessary deleterious impact on the aged based on inaccurate assumptions about the effects of age on ability, there are often solid grounds for importing benefits on one age group over another in the development of broad social schemes in allocating benefits. The careful manner in which the General Assembly resolution on the rights of the aged is framed is worth noting. Its recommendation discouraging discriminatory practices in employment based exclusively on age is prefaced by the words that this be done wherever and whenever the overall situation allows. As such, we observe that unlike other forms of discrimination, there might well be instances where what one might conceive to be in discrimination is in fact not to be so offensive, instead being grounded in factually substantiated decreases in ability and productivity. And unfortunately, it could well go into analytics pertaining to employee cost analysis that could support using younger employees to realize higher profits per employee. Nevertheless, depending upon the position and the variables that are being analyzed versus those that are disregarded or given lesser weight, can be countered based upon the alteration of the inputs, metrics, computations, and comparative analysis, such that results can be fundamentally altered and seriously challenge the assertion that age discrimination was not in play. Such a rationale for an employer's actions, nevertheless, is far better than the situation that tends to be found with other forms of alleged discrimination, such as discriminatory employment practices based on race, religion, ethnicity, gender, and sexual orientation. In those situations, there is not an acceptable rationale for selecting one individual over another individual on the basis of race, religion, ethnicity, gender, or sexual orientation, with there being no economic metrics that might be capable of substantiating one's position and at least providing the employer with a plausible argument, even though it might ultimately fail in a court of law. It still had the possibility of limiting or reducing any damage award. As Justice LaForest went on to observe, what we are confronted with is a complex socioeconomic problem that involves the basic and interconnected rules of the workplace throughout the whole of our society. As already mentioned, the legislature was not operating in a vacuum. Mandatory retirement has long been with us. It is widespread throughout the labor market. It involves 50% of the workforce. The legislature's concerns were with the ramifications of changing what had for long been the rule on such important social issues as its effect on pension plans, youth employment, the desirability of those in the workplace to bargain for and organize their own terms of employment, the advantages flowing from expectations and ongoing arrangements about terms of employment, including not only retirement but seniority and tenure, and indeed almost every aspect of the employer-employee relationship. These issues are surely of pressing and substantial concern in a free and democratic society. And as Justice Gray observed, this conclusion is generally reinforced by reference to other industrialized democracies. The United States, the United Kingdom, Ireland, Australia, the Federal Republic of Germany, Norway, and Japan all recognize some form of pension-associated mandatory retirement. This only begins to reveal the level of complexity that is involved in assessing and applying matters of age discrimination as against rational business practices, which have been structured to allow for the eventual departure of more senior employees based on a structure that protects the business while positioning the more senior employees to prepare and absorb the eventual impact of their departure from the business so as to facilitate its continued business cycle. Thank you.